Good day, everyone. Today we will learn the basic definitions of sales of goods under Section 4, Subsection 1 of Sales of Goods Act. So here, a sale of goods is a contract whereby a seller transfer or agree to transfer the property in goods to the buyer for a price. So let's break this into three simple elements. Number one, goods. These are the items being sold. Examples like phone, laptop, clothes, and food. Number two, transfer of property. The seller must transfer ownership or agree to transfer ownership to the buyer. This means the buyer becomes the legal owner of the goods. Number three, price. There must be money involved. If there is no price, it is not a sale of goods. So, to confirm a sale of goods, always check. Number one, is there goods? Number two, is there transfer of ownership? And number three, is there price or money? If all three are present, then it is a sale of goods under SOGA. Next, let's look at what is goods. Under Section 2 of SOGA, or Sales of Goods Act, goods means every kind of movable property except money and actionable claims. In simple words, goods are things that you can move and sell. Examples of goods from the slides. Number one, stocks and shares, which is the ownership in a company can be treated as goods. Number two, things attached to land to be cut or separated. Example, timber or trees that can be cut and sold. Number three, growing crops. Examples like vegetables, fruits, or paddy that will be harvested. Money and actionable claims are not goods. Actionable claims, examples like debts and legal rights. So to identify goods, just remember, number one, it must be movable. Number two, it can include crops, stocks, things to be separated from land. And number three, must not be money or legal claims. So, under SOGA, the following are not goods. Number one, land and things attached to land. Land itself is not goods. Buildings, houses, and fixed items are also not goods. However, if something is to be separated, it will become goods. For examples like timber, where you have a trees to be cut down, or harvested crops. Number two, choices in actions or rights. These are legal rights, not physical items. Examples like debts or patents. You cannot physically hold them, so they are not goods. Number three, services. Work done by a person is not goods. For example, repair services, labor work, and also cleaning services. So, remember, goods are tangible and movable property only. Not goods are like land, legal rights, and services. Here, we are going to look at the types of goods. Goods can be divided into three main types. Number one, existing goods. These are goods that already exist and are owned or possessed by the seller. They are available at the time the contract is made. Number two, specific goods. These are goods that are clearly identified and agreed upon at the time of the contract. Not just existing, but exact item already chosen. Number three is future goods. These are goods that are not yet exist at the time of contract. They will be manufactured, produced, or acquired later by the seller. So remember, existing goods, it's already there. Specific goods have already been chosen. and future goods, it's not ready yet. Next, let's look at certain goods and uncertain goods. These are goods that are not identified at the beginning, but later become clearly identified, and that is certain goods. So in simple terms, certain goods are the exact goods that are confirmed after selection by the buyer or the seller. Number two is uncertain goods. These are goods that exist but are not yet specifically identified at the time of the contract. They are only described in general terms. So, simple example for you. Ali agrees to buy 10 bags of rice from a warehouse of 100 bags. At first, no specific bags are chosen. So, this is uncertain goods. Later, the seller selects 10 specific bags and separates them. Now, the goods are clearly identified. So this is certain goods. Let's look at the contract of sales under section 4 of SOGA. So what is a contract of sales? Under section 4, subsection 1 SOGA 1957, a contract of sale is a contract where the seller transfers or agrees to transfer ownership of property in goods to the buyer for a price. So when does a sale happen? A sale occurs when the ownership of goods passes to the buyer. So there are three important elements. For a valid contract of sale, there must be, number one, goods, which is something movable, examples like phone, car, or food. Number two, price. It must involve money. When there's no money, means there's no sales. Number three is the transfer of property or the ownership. The ownership must pass or agreed to pass to the buyer. So always remember, goods, price, and transfer of ownership makes a valid contract of sales. Next, let's look at agreement to sell. Here, we need to understand what is a sale. A sale happens when the ownership or the property of goods is immediately transferred from seller to buyer. The buyer becomes the owner right away. So, number two, what is an agreement to sell? Under section 4, subsection 3 of SOGA, an agreement to sell is when the transfer of ownership will happen in the future or after certain conditions are fulfilled. However, the ownership is not transferred yet. So, when does agreement become sale? Under section 4, subsection 4 of SOGA, an agreement to sell becomes a sale when the time has passed or the condition is fulfilled. The ownership is officially transferred. Next, let's look at the formation of contract of sales under section 5 of SOGA. So, the basic formation under section 5, subsection 1 of SOGA, a contract of sale is made by an offer and acceptance. This means one party makes an offer, which is to buy or sell the goods, and the other party accepts the offer. So once accepted, a valid contract is formed. Number two, delivery and payment. The contract may include immediate delivery of goods or immediate payment of price or both at the same time. It depends on the agreement between the parties. Number three, payment by installment. The law allows payment to be made in installments. Buyer can pay little by little over time. So, to form a contract of sale, there must be an offer and acceptance. That's enough to form a valid contract. Next is the formality of contract of sales. Number one, formality of contract. Under section 5, subsection 2 SOGA, a contract of sale can be made in many ways. It can be in writing, examples like agreement document, or oral, or the word of mouth, or both writing and oral, and also implied from conduct, which is based on action. This means even without a written agreement, a contract can still be valid. For a simple example, you can go to a shop, pick a drink, and pay at the counter. There's no written contract, no formal discussion, but your action shows agreement. So this is a valid contract. Number two is price, which is very important. Price is money paid for the goods. It must involve money. If there's no money, means there's no sale of goods. Number three, how price can be determined. Price can be fixed in 4 ways. Number one, fixed in the contract. Examples like price of a phone is RM 1,000 ringgit. It is fixed. Number two, fixed letter or agreed method. Example, price based on market rate next week. Number three, based on past dealings, based on previous transactions between the parties. Number four is reasonable price. If no price is agreed, buyer must pay a reasonable price. So, easy tips for you to remember. When there's no money, there's no sales. There's no form needed, and it's still a valid contract. Next, capacity to contract. What is capacity to contract? Capacity means a person's legal ability to enter into a contract. Not everyone is allowed to make a valid contract. Under the Contract Act of 1950, the rules about capacity in general contract law also apply to sale of goods contract. So, who has capacity? A person can enter into a valid contract if they are, number one, of sound mind, means they can understand the contract. Number two, not a minor, which is below 18 years old. And number three, not disqualified by law. Examples like a bankrupt person in some situation. So, who does not have capacity? Number one, minor, those who are below 18 years old. Number two, persons of unsound mind. And number three, persons disqualified by law. So, always check, is the person 18 years old and above? Is the person of sound mind? If yes, then it is a valid capacity. If not, the contract may be invalid. Next, let's look at conditions and warranty under SOGA. So, in a contract, there are terms or promises made by the seller. These terms can be condition, which is very important, and warranty, which is less important. So, if the buyer fails to check the goods properly, the buyer may lose the right to complain later. These include quality of goods, conditions of goods, and the fitness for purpose. Meaning, number one, the condition, a major term of the contract. If it's broken, then the buyer can reject the goods and claim the refund. Number two, warranty, a minor term of the contract. If broken, buyer can claim damages only, but cannot reject the goods. So, I give you a simple example. Ali buys a new phone. If it's under condition, then the phone must be original and working. If it's under warranty, minor issues like small scratches. If the phone is fake and the condition is breached, Ali can reject the phone. If the phone has small scratches, then the warranty breached, Ali can only claim compensation. Right? Next, let's look into condition. What is a condition? Under Section 12 of Subsection 2 of SOGA, a condition is a term that is essential to the main purpose of the contract. This means it is very important. What are the effects of breach of condition? If a condition is broken, the innocent party can reject the contract. This is called repudiating the contract. But there's an important exception. Sometimes, even if a condition is breached, the buyer cannot reject the goods, only claim damages. So what are the situations where buyer cannot reject? Number one, buyer waives the condition, means the buyer chooses to accept the goods. Number two, buyer treats it as a warranty, where the buyer only wants compensation. Number three, buyer has accepted the goods, which is non-severable contract. Example, he already used or kept the goods. And number four, property has already passed to the buyer, which the ownership has already been transferred. So, condition is a very important term. If there's a breach of condition, a buyer can reject the contract. But in some cases, they can only claim damages. Now let's look at warranty. Warranty is another important term in the contract of sales. So under section 12, subsection 3 of SOGA, a warranty is a term that is not essential to the main purpose of the contract. So it is less important. It is a minor term. So what is the effect of breach of warranty? If a warranty is broken, the buyer cannot reject the goods. The buyer cannot cancel the contract. The buyer can only claim damages or the compensation. So, warranty is a minor term, and if there's any breach of warranty, you can only claim damages and you cannot cancel the contract. Next, we are going to look at the remedies for unpaid seller and remedies for the buyers. So, who is an unpaid seller? A seller is considered unpaid when the full price has not been paid. The buyer still owes money, or payment by check or bill fails. The seller received payment, but it was dishonored or bounced. So even if the buyer promises to pay, if the money is not actually received, the seller is still considered unpaid. So the law gives special right to an unpaid seller to protect them because they already gave the goods but did not receive full payment. So an unpaid seller is a seller who is not fully paid or the payment is failed. So it includes partial payment or dishonored check. So let's look at the specific rights of an unpaid seller against the goods. So right of lien, keep the goods. If the seller still has the goods, the seller can keep or retain the goods until payment is made. This is called lien. Right of stoppage in transit. If the seller has already sent the goods, but the buyer becomes insolvent or unable to pay, the seller can stop the goods while they are in transit. Number three, right of resale. If the seller can sell the goods again to another buyer, especially when buyer fails to pay or delays payment. And number four, right to withhold delivery. If ownership has not yet passed to the buyer, the seller can refuse to deliver the goods. So, four important rights for an unpaid seller. Number one is lien, keep the goods. Number two, stoppage in transit, which is to stop the delivery. Number three, resell, where you sell it to someone else. And number four, withhold delivery, which is do not deliver. So let's look at one by one. Lien, the right of the seller to keep the goods until the buyer pays the price. In simple terms, no payment, so the seller can keep the goods. Under section 47, subsection 1 of SOGA, an unpaid seller who still has possessions of the goods can retain or keep the goods until payment is made. So the seller can exercise in this situation. Number one, when there is no credit given. Goods sold without any payment period. So we are expected the payment to be made immediately. Number two, credit period has expired. Buyer was allowed to pay later, but the time is over and still not paid. Number three, buyer fails to pay. General situation where price is not settled. So the key point here for you to remember, lien only applies when the seller still has possessions of the goods. And if goods already delivered, lien is no longer applies. Then seller may use other rights like stoppage in transit. Next, stoppage in transit. Under Section 50 of SOGA, if the buyer becomes insolvent, the unpaid seller can stop the goods while they are still in transit. This means the seller already sent the goods, but the buyer cannot pay. So the seller can take back the goods before they reach the buyer. So when can this right be used? There are two important conditions. Number one, seller has already parted with possession. Goods are no longer with the seller. Number two, buyer becomes insolvent where he cannot pay the debts. So both must exist, then seller can act. So what does in transit means? Goods are considered in transit when they are being delivered. Examples, in lorry, ship, or courier. It is not yet received by the buyer. So the seller can regain possessions of goods and keep them until payment is made. Next, we are going to look at the resell. So under Section 54 of SOGA, when a seller exercises lien, which is he keeps the goods, or stoppage in transit, where he stops the delivery, the contract is not cancelled automatically. This means the seller cannot simply resell the goods immediately. So when can the seller resell? Under Section 54, subsection 2 of SOGA, the seller can resell in three situations. Number one, perishable goods, goods that can spoil quickly. Examples like food, fruit. Seller can resell immediately to avoid loss. Number two, notice given to buyer. Seller informs the buyer, I will resell the goods if you don't pay. And if the buyer still does not pay within reasonable time, then the seller can resell the goods. Number three, rights of resale reserved. The contract already states seller has the right to resell if buyer defaults. If buyer fails to pay, seller can resell immediately. So, seller cannot resell freely at first, but it can resell when goods are perishable, notice is given to the buyer, and the buyer fails to pay, and the contract allows right of a resell. Next, remedies of the buyer. So let's look at the remedies available to the buyer when the seller fails to deliver the goods. So number one, actions for non-delivery under Section 57 of SOGA. If the seller wrongfully refuses or neglects to deliver the goods, the buyer can sue the seller for damages, which means the buyer gets compensation or money in the loss or for the loss suffered. Number two, specific performance under Section 58 of SOGA. In certain cases, the buyer does not want money, but the buyer wants the actual goods. So the buyer can ask the court for specific performance. So when is specific performance used? Usually when goods are unique, special, hard to replace. Examples like valuable painting, rare antique, and limited edition item. So for buyer's remedy, for non-delivery, he can claim damages under Section 57. If it's a special goods, he can ask for specific performance under Section 58. Next, let's look at the Consumer Protection Act 1999 under Malaysia. So the main objective, the purpose of this act is to protect the consumers from unfair practices and to ensure that the goods are safe and the goods are of acceptable quality. Number two, the consumer rights. If a consumer is not satisfied, they have the right to make claim or complaint. If the claim is less than 10,000, the consumer can go to Consumer Claims Tribunal ataupun Tribunal Tuntutan Pengguna. Number three, implied guarantees. The law automatically guarantees that goods are of acceptable quality, are fit for purpose, and match the descriptions and have available repairs or spare parts. Number four, if goods fail, if the product does not meet the guarantees, the consumer can ask for repair, ask for replacement, and claim damages. So, Consumer Protection Act 1999 protects the consumer. It covers the quality, safety, and performance. Consumer can claim through the tribunal, and the consumer has the right to repair, replace, or claim damages. Thank you very much, and I'll see you guys again on our next topic.